So we are here this morning in Denver interviewing our area patent attorney, Mark Trenner. And Mark has been practicing as a patent attorney in Colorado for almost 14 years, the past 9 years at Trenner Law Firm. And while his practice focuses primarily on helping small businesses protect their inventions with patents, his law firm also assists clients to build out all aspects of their intellectual property portfolio, including copyrights, trademarks, and trade secrets. So, Mark, the Washington Post recently published an article titled "How Vermont Could Save the Nation from Patent Trolls." Now, what do they mean by patent trolls?
Hey Dan, well, patent trolls have actually been in the news quite a lot lately. In fact, if you or any of the viewers follow me on Twitter, then they've probably seen some links to some interesting articles recently. Wikipedia actually gives a good definition of a patent troll. A patent troll, also called a patent assertion entity, or PAE, is a person or company who enforces patent rights against accused infringers in an attempt to collect licensing fees, but does not manufacture products or supply services based upon the patents in question. Sometimes patent trolls are even called patent holding companies, so you may have heard that term used as well.
Well, I've also heard that universities and government research facilities do essentially the same thing.
But by that you mean they develop technology, they patent it, and then they license the technology to companies.
Right, but since they're not in the business of making products, does that make them patent trolls?
No, universities and government laboratories typically are not labeled as patent trolls. Instead, they're referred to as what we call non-practicing entities, or NPEs.
So why aren't they considered patent trolls?
Well, universities and research laboratories are generally considered to be making developments and advancements for the good of people. They're not going around trying to shut businesses down. They're trying to start businesses up and get a product out there. So while government laboratories and universities have the resources and capabilities to conduct important research, that's what their professors primarily get paid to do, like cancer research and other preventative disease research, they typically are not well suited to deploy any products. So rather than have this research just sit there and be published in papers and not actually make it into a product, these laboratories, these universities will collaborate with businesses that do have the means to develop, test, and bring these products to market. So no, these laboratories generally are not considered to be patent trolls, that they have a different goal.
Gotcha. So why is there such a negative connotation for patent trolls?
Well, you've probably read in some of the articles I've linked to on my Twitter account that these patent trolls go out and they obtain patents and then go after companies that are actually making products. The patent troll isn't making them, but they're seeking damages from companies who are. So they're not bringing anything to the marketplace. They just asked for money damages, even so there really was no damages to the patent troll. The patent troll never really tried to bring a product to market. They're just trying to collect money and, even worse, stop legitimate companies from manufacturing products.
So what are the states doing to stop these patent trolls?
It's interesting. The article says that Nebraska sent a letter to one of the law firms allegedly representing patent trolls, asking the law firm to leave Nebraska businesses alone. The article says that the letter apparently warned the law firm that it would face serious consequences under Nebraska law if it engaged in baseless harassment of Nebraska businesses or pursued costly and destructive litigation.
I thought the article was about Vermont.
Yeah, it is, but the article also explains that Nebraska is the second state going after these so-called frivolous lawsuits.
And Vermont is the first state?
That's right. Apparently, Nebraska was inspired by Vermont, who filed a lawsuit in May against a patent holding company after several businesses in Vermont were threatened. Apparently, even 2 Vermont charities were threatened by the patent holding company.
Wow. Are any of the states successful in deterring these patent trolls?
I think that's yet to be seen, but a lot of companies and even some charities, according to this article, are being threatened by patent trolls with this allegedly baseless litigation, and so it's definitely making the headlines lately.
Are there any laws specifically on point?
Well, the article does mention the use of Vermont's Consumer Protection Act, and a lot of states do have a Consumer Protection Act. It also said that legislation was passed in May in Vermont that gives someone accused of patent infringement the right to countersue if it's in bad faith. Of course, proving bad faith is a whole other issue in itself.
Well, it sounds like we're going to be hearing a lot more about patent trolls. Thank you, Mark. That's all the time we have for today. For more information, be sure to visit the Trenner Law Firm's website at us-patentattorney.com, and you can visit Mark's blog over at ipatentattorney.org. Thanks again, Mark. Have a good one.
Thanks, Dan.